Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For our third and final case in this trifecta of cases, it brings us to Casey versus Planned Parenthood. This is, of course, the modern case that defines the abortion right in the United States, decided in 1992 at the United States Supreme Court. In this case, the United States Supreme Court was asked to revisit its decision in Roe from some 20 years earlier. And there was a lot of expectation at the time that Roe would be reversed. So the expectation at the time was Roe was going to go the way of the dodo, but that didn't happen. Roe itself was modified substantially and heavily. So it's a little bit of an error these days to talk about Roe versus Wade. The dominant case on point is clearly Casey versus Planned Parenthood. Now, some people use Roe as just kind of a placeholder, but strictly speaking, people really shouldn't talk about Roe. They should talk about Casey. And so we're going to learn about Casey because it is the dominant case on abortion law as it applies at this point. So let's get started with this. Liberty finds no refuge in a jurisprudence of doubt. Yet 19 years after the holding of the Constitution that protects a woman's right to terminate pregnancy in the early stages, held in Roe, the definition of liberty is still questioned. So, as will surprise absolutely no one, in the aftermath of Roe versus Wade, there were many, many legal challenges to overturning, as there continues to exist today, for that matter. And this was thought to overturn Roe, and it didn't happen. So let's learn a little bit about why. Constitutional protection of women's decision to terminate pregnancy derives from the Due Process Clause of the 14th Amendment. It declares that no state shall deprive any person of life, liberty, or property without due process of law. The controlling word in the clause before us is the word liberty, although a literal reading of the clause might suggest that it governs only procedures by which a state may deprive persons of liberty. For at least 105 years, the clause has been understood to contain a substantive component as well, one barring certain government actions regardless of fairness of procedures used to implement this. So yeah, this is also incidentally something that drives conservative legal thinking up the wall. The entire concept of substantive due process isn't one that conservatives believe in from first principles. And Justice Thomas continues to make this clear every chance he gets. We had something perfectly serviceable in the 14th Amendment called the Privileges or Immunities Clause. It was great. The Privileges or Immunities Clause was going to do all this wonderful stuff for it, and then the Supreme Court nuked it. They nuked it. They nuked a part of the Constitution. They rendered it out of existence, principally in a case called the Slaughterhouse cases, which we've covered before, and makes the conservatives super, super grumpy. Now, the Supreme Court could have simply said, we made a mistake. We shouldn't have done that. But they didn't do that. They said, no, we were completely correct the first time to completely nuke a part of the Constitution. But how can we fix this problem? I know what we'll do. We'll create an idea of substantive process. You hearing that? Substantive process. Like these two words aren't directly contradicting each other. Process. Substance. So that's how we'll solve the problem. So yeah, for 105 years, give or take, we've been solving the problem that we nuked the Privileges or Immunities Clause, which was designed to do all this for us. And instead, we create the idea of substantive due process, which drives conservatives completely up the wall, banana cuckoo for Cocoa Puffs. Now, even Justice Scalia said, yeah, it's too late. Let's just accept it. But from first principles, the conservatives go nuts. But yes, liberty is in fact understood to include substantive due process because, I don't know, reasons. But let's not worry about that right now. Let's press on. The most familiar of these substantive liberties protected by the 14th Amendment are those recognized by the Bill of Rights. We have held the Due Process Clause of the 14th Amendment incorporates most of the Bill of Rights against the states. It is tempting as a mean of curbing discretion among federal judges to suppose that liberty encompasses no more than those rights already guaranteed to individuals against federal interference by express provisions of the Constitution. See, for example, Amundsen with Black dissenting. We've discussed Justice Black before. He definitely doesn't believe in this. But of course, this court has never accepted that view. That's true. They never agreed with Black. Black was definitely an outlier. But yeah, Justice Black holding the cause dear for only what's in the Constitution applies and nothing more. Justice Black is hardcore. He's too hardcore for the conservatives today. We're softer than this. Justice Black was hard. He was hard OG, man. Gotta get some respect for him, even though we don't roll that deep anymore. But he rolled deep, baby. The inescapable fact that adjudication of substantive due process claims may call upon the court in interpreting the Constitution to exercise the same capacity by which traditional courts have always exercised reasoned judgment. Its boundaries are not susceptible of expression as a simple rule. That does not mean that we're free to invalidate state policy choices with which we disagree, yet neither does it permit us to shrink from the duties of our office. So, yeah, we can't invalidate the state what they do, but we can invalidate what the state does because, yeah, I don't know, reasons. Men and women of good conscience can disagree, and we suppose some shall always disagree about profound moral and spiritual implications of terminating a pregnancy, even in its earliest stages, which, people definitely disagree about today for very legitimate reasons, to be sure. I mean, there's a point to be had everywhere along the spectrum. I mean, you can definitely defend the idea of that abortion should never be allowed. I mean, it's a logically tenable reason. So that makes sense to some degree. Some of us as individuals find abortion offensive to our most basic principles of morality, but cannot control our own decision. Men and women of good conscience can disagree, and we suppose some shall always disagree about profound moral consequences of terminating a pregnancy, even in its early stages. Some of us as individuals find abortion offensive to our most basic principles of morality, but that cannot control our decision. Our obligation is to define the liberty of all, not to mandate to our own moral code, which I suppose is true enough. The moral code of judges shouldn't be what guides. What should guide is, the Constitution. So find me this in the Constitution, we'll talk. But, the underlying constitutional issue is where the state can resolve these philosophical questions in such a definitive way that a woman lacks all choice in the matter, except perhaps in those rare circumstances where pregnancy itself is a danger to her own life or health or as a result of rape or incest. The problem here is that no one really seems to contend that the state can regulate every other area of medical practice. That's the problem. Like, no one seems to contend that the state can ban other medical things or ban other medical treatments. I mean, if you want pot for your medical needs, the federal government will tell you to STFU, for example, if you need it. But, for some reason, the state can't regulate abortion, even if it can regulate other kinds of medicine. This is very strange. It's conventional constitutional doctrine that where reasonable people disagree, the government can adopt one position over another. That theorem, however, assumes a state of affairs in which choice does not intrude upon protected liberty. Thus, while some people might disagree about whether or not the flag should be saluted or disagree about the proposition that may not be defiled, we have ruled a state may not compel or enforce one view or the other. Though the abortion decision may originate within a zone of consciousness and belief, it is more than a philosophical exercise. Abortion is a unique act. It is an act fraught with consequences for others. Yeah, depending on your definition of others, very fraught with consequences to one specific other, it might be noted. For the woman who must live with the implications of her decision, for the person who performs and assists in the procedure, for the spouse, family, and society which must confront the knowledge that these exist, procedures some deem nothing short of an act of violence against an innocent human life, and depending on one's own beliefs, for the life or potential life that's aborted, which murder. So that might be potentially a factor to be considered, depending on your philosophy. Though abortion is conduct, it does not follow the state is entitled to prescribe it in all instances. Why? The state is entitled to prescribe pretty much all other medical procedures that they want. What other medical procedures do you have the right to do that the state can't provide or regulate or even forbid? I mean, I'd love to know the answer to this question. Is it just abortion for some reason? Apparently. That is because the liberty of woman is at stake in a sense unique to the human condition and so unique to law. I'm not sure if I completely buy that, to be completely honest. I mean, there's some aspects of it that are somewhat unique, but you can make a colorable argument about other things. And why is its uniqueness dispositive? Even if assuming that it is unique among women, then why is that, dispositive? I don't know. The mother who carries the child to full term is subject to anxiety, to physical constraints, to pain that only she must bear. Less so with epidurals, but noted. These sacrifices have from the beginning of the human race been endured by women with a pride that ennobles her to the eyes of others and gives infant a bond of love that cannot be alone for the grounds of state to insist she make the sacrifice, even if it means terminating another person, which, might be a factor again. Her suffering is too intimate and personal for the state to insist, without more, upon its own vision of the woman's role, however dominant that vision has become in course of history and culture. The destiny of women must be shaped to a large extent by her own conception of spiritual imperatives and place in society. I mean, society can determine a lot of what's right and what's wrong for other people. Society can impose on people to a large extent and view as society's morality. So, I mean, if you accept this proposition, I understand, but the limits of the proposition is a little bit hard to find. So it's like, if you buy this thinking, that's fine, but like, why is it limited in this specific context? That's more my point. It's like, you can justify this within its own context in some ways, but why is it limited in that context? Once you accept the principle, like, why is it limited here? Why this procedure, not other procedures? Why this pain, not other pains? Why can't society impose its morality here, but they can elsewhere? You know, so, and why can they impose it in other medical domains and not this domain? So I'm not saying that you can't accept this premise within its confines. You can. It's just a little unclear once you do so. Why does it remain within those confines? That's the part that I think trips someone up. It's like, why are we limiting it here exactly and not? It's like, why doesn't this read elsewhere? It's a little bit, why doesn't this extend beyond its own terms? It should be recognized, moreover, that in some critical respects to abortion is, of course, the same character as use of contraception, to which Griswold extends constitutional protection. That seems a very strange proposition to me. That in some critical respects, abortion is of the same character as the decision to use contraception? That seems a slightly strange proposition. I'm going to say it again. Abortion is of the same character as the decision to use contraception. Really? Really, Supreme Court? Okay. They support the reasoning that Roe's relation to women's liberty because they involve personal decisions concerning not only the meaning of procreation, but also human responsibility and respect for it. As with abortion, reasonable people have differences of opinions about these matters. I suppose reasonable people might have differences about conception, but are there a lot of people who think conception and abortion are the same thing? One's view is based on such reference for wonder of creation, that any pregnancy ought to be welcomed and carried to full term, no matter how difficult it prove for the child and ensure its well-being. Another is the inability to provide for the nurture and care of others is cruel to the child and anguishing to the parent. These are intimate views with an infinite variations, and their deep, personal character outlier decisions in Griswold. The same concerns are present when a woman confronts the reality that perhaps her best defense to avoid it, she becomes pregnant. I mean, again, you could look at this differently if you wanted, but it's like, it's not quite the same moral character. It's a strange proposition. The obligation to follow our precedent begins with necessity, and a contrary necessity marks its outer limits. We recognize that no judicial system could do its society's work if each issue was vied afresh of every case that raised it. So in this case, we may inquire where Roe's central rule has found to be unworkable, whether its rule's limitation on state power could be removed without serious inequity to those who rely upon its significant damage to the stability of society governed by it, where law's growth in intervening years has left Roe's central rule a ductile anachronism, or whether Roe's premises have, in fact, so far been changed in ensuring 2 decades is rendered its central holding somehow irrelevant or unjustifiable. Now, this paragraph right here in Casey is really, really important, because this paragraph speaks to the value of precedent as a fundamental concept. So remove this paragraph completely from the context of abortion, because a lot of people, including myself, for example, why we don't necessarily think this is the end-all be-all, think it's as good an explanation of precedent as a concept as any has ever been expressed. So this may not be the end of the analysis. This may not be the only thing, but this is as good as ever been done. So this is more fundamentally, when should we overrule precedent? So forgetting Roe for an example, this is what the Supreme Court says the rule on precedents at large should be. Has it proved to be unworkable? Could this be removed without significant damage to stability? Would this upset stability in such a way that would be problematic? Whether the law's growth has rendered a doctrinal anachronism discontinued. Basically, has the central holding of it been worked apart? Has so many holes been put in it that the legal theory has no longer helped? So has subsequent legal development undermined the central holding? And has it rendered it irrelevant or unjustifiable? So those are like 4 major grounds of looking at case law in general. So this paragraph has extended well beyond the abortion context to precedent at large, and it should be looked to for that proposition as well. It's a majorly important paragraph, regardless of what you think about the underlying issue of abortion. So turning to the factors as it applies to abortion, although Roe has endangered opposition, it has not been unworkable. That's fair enough. I mean, it has not been unworkable. We've applied a standard. It has proven to be applicable. So fair enough. The inquiry into the reliance interest counts the court's rule reputation as would fall on others who have reasonably relied on it. So what is the reliance interest? While neither respondents nor amici in so many words deny the abortion right involves some reliance prior to actual exercise, one could imagine the argument stressing dissimilarity in those involving contracts. So you don't necessarily have a reliance interest in abortion as such as you would in like a contract or any other law, because you're not going to need abortion until you need it. So you don't really have reliance until you need it. So you could sever it there if you want to. Abortion is customarily chosen as an unplanned response to the consequence of unplanned activity or to failure of birth control, and except on the assumption that no intercourse would have occurred but for this holding, such behavior may appear to justify no reliance claim. So so some have argued there's no reliance. And the court says to eliminate this issue of reliance entirely, however, would be to limit cognizable reliance to specific instances of sexual activity. But to do so would simply refuse to face the fact that for 2 decades, people have organized their relationships and made choices that define themselves and their place in reliance on this. The ability of the women to participate equally in this has been facilitated by their ability. So whether or not you buy that, because presumably if Roe changed, women would make different decisions, but they say there's a reliance interest. So I personally find that a little bit weak, but the Supreme Court said what it said. No evolution of legal principles has left Roe's doctrinal footing weaker than when it was in 1973. No development of the law since this case has been decided has implicitly or explicitly left Roe behind as a mere survivor of an obsolete constitutional thinking. It will be recognized, of course, that Roe stands at the intersection of 2 lines of decisions, but whatever doctrinal category one reads in the case, the results will be the same. Roe may be seen not only as an exemplar of Griswold's liberty, but as a rule of personal autonomy and bodily integrity, which again seems to only apply in the abortion context for some reason, because the state can ban other kinds of surgeries or treatments if they like, with the tyrannical ability for cases to recognize limits on government power to mandate medical treatment or bars its rejection. If so, our case since Roe accords with the view the state's interest in protection falls short of justifying any plenary overview of liberty claims. Finally, one could classify Roe as a sui generis, which is a case unto itself, self-generating. So this view that clearly has been no erosion as to its central determination. The soundness of this prong of the analysis is apparent from consideration of the alternative. If indeed the woman's interest in deciding whether to bear and beget a child had not been recognized in Roe, the state might readily restrict a woman's right to choose to carry to pregnancy a term as determinated, but further asserted state interest in population control or eugenics, for example. Yet Roe has been sensibly relied upon to counter a suggestion. We have seen how time has overtaken some of Roe's factual assumptions. Advances in maternal health care now allow for abortions safe to the mother late in pregnancy that was true in 1973, and advances in neonatal care have advanced viability at some point earlier. The country's loss of confidence in the judiciary would be underscored by an equally certain and equally reasonable condemnation for another failing and overruling unnecessarily and under pressure. Some costs will be paid by anyone who approves or implements a constitutional decision where it's unpopular or refuses to work to undermine the decision or to force its reversal. The price may be criticism or ostracism, or it may be violence. An extra price will be paid by those who themselves disapprove of the results when viewed outside its constitutional terms, but who nevertheless struggle to accept it because they respect the rule of law. To all those who will be tested by following, the court implicitly undertakes to remain steadfast, lest it end in a price to be paid for nothing. The promise of consistency, once given, binds the maker for as long as the power to stand by the decision survives and undertake the issue has not so fundamentally changed as rendered the commitment obsolete. That brings us, of course, to the point where much criticism has been directed at Roe, a criticism that also adheres to where the court draws a specific rule in which the Constitution has a standard. And this is where the Casey changes Roe significantly. We conclude the line should be drawn at viability. So before the time of viability, a woman has a right to terminate her pregnancy. We adhere to this principle for 2 reasons. First, as we said, is the doctrine of stare decisis. A judicial act of line drawing may be somewhat arbitrary, but Roe's was a reasoned statement. I'll elaborate with great care. We've twice affirmed it in face of great opposition. The second reason is the concept of viability. As we noted in Roe, is a time at which there's a realistic possibility of maintaining and nourishing life outside the womb. So the independent existence of the second life can, in reason and all fairness, be an object to state protection that now overrides the rights of a woman. The woman's right to terminate her pregnancy before viability is the most central principle of Roe. It is a rule of law and component of liberty that we cannot renounce. So the Supreme Court is now going to further modify Roe. So Roe really went for this trimester system. So it went first trimester, abortion is permitted. Second trimester, it can be regulated. Third trimester, it can be forbidden. All right, that was Roe. First trimester permitted, second trimester permitted, but regulated, third trimester forbidden. So now the Supreme Court is going to get into modifying that framework. So the court continues. Roe established the trimester framework to govern abortion. Under this elaborate but rigid construct, almost no regulation is all permitted during the first trimester. Regulations designed to protect women's health, but no further than state's interest in potential life, are permitted during the second trimester, and during the third trimester, when the fetus is viable, prohibitions are permitted except for life or health of the mother. The trimester framework, no doubt, was erected to ensure a woman's right to choose not become subordinate to the state's interest in promoting life, that her choice exists in theory but not in fact. We do not agree, however, that this trimester approach is necessarily accomplishes the objective. A framework this rigid was unnecessary, and later interpretation sometimes contradicted the state's power. Though a woman has a right to terminate or continue her pregnancy before viability, it does not follow the state is prohibited from taking steps to ensure this choice is thoughtful and informed. Even in the early stages of pregnancy, the state may enact rules and regulations designed to encourage her to know there are philosophical and social arguments of great weight that can be brought in favor of continuing the pregnancy to full term, and there are procedures and institutions to allow for adoption of unborn children, as well as a certain degree of state assistance if the mother chooses to raise the child herself. The Constitution does not forbid a state or city, pursuant to democratic processes, from expressing a preference for a normal childbirth. The abortion right is similar. Numerous forms of state regulation might have an incidental effect of increasing costs or decreasing availability of care, whether for abortion or any medical procedure. The fact that a law which serves a valid purpose, one not designed to strike at the right itself, the incidental effect of making it more difficult or more expensive to procure an abortion cannot be enough to invalidate it. Only where state regulation imposes an undue burden on a woman's ability to make the decision does the power of state reach into the heart of liberty protected by the Due Process Clause. A finding of undue burden is shorthand for conclusion that a state's regulation has a purpose or effect of placing a substantial obstacle in the path of a woman seeking abortion of a non-viable fetus. A finding of undue burden is shorthand for the conclusion that state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking abortion for a non-viable fetus. A statute with this person is invalid because it means chosen by the state to further interest in potential life must be calculated to inform a woman's free choice, not to hinder it. And a statute which, while promoting an interest in potential life or some other state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a permissible means of serving this end. To the extent the opinions of the Court of Individual Justices use the undue burden standard and are inconsistent with this analysis, we set out what the view should be with the controlling standard. Our Constitution is a covenant running from the first generation of Americans to us and then to future generations. It is a coherent succession. Every generation must learn anew the Constitution's written terms embody the ideas and aspirations that must survive more than ages than our own. We accept responsibility not only to retreat from interpreting the full meaning of the covenant in light of our precedents, we invoke it once again to define the freedoms guaranteed by the Constitution's own promise, the promise of liberty. Thus, that brings us to the end of our discussion of Planned Parenthood versus Casey, a case which heavily modifies Roe to move from a trimester framework to one that establishes viability as the period of cutoff. So under the current law as today, abortions have to be allowed before viability, can be restricted or banned after viability, and for those restrictions even before viability, the court talks about what undue burden is. And we've been arguing about what undue burden is for quite a while now, because that's been the dominant issue. But that's where the case leaves us. So hopefully this was helpful to summarize the current case laws that relates to abortion and procreation between our coverage of Griswold, Roe, and Planned Parenthood. And that, for the moment, brings us to the end of the discussion of this series of cases. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.